Thanks, Kathleen. Thanks, Minister. I just want to come in on this because we did actually have this discussion at committee stage, and I welcome that that this has been included, and I think it's important, and it was an important point that was made, I suppose, about lots of different arrangements that we've all seen various stories over the years. That obviously there was very formal arrangements, but there was informal as well, and I think it's important to be as inclusive as possible with this legislation. I just want to welcome the fact that that's in there. Thanks,
Thank you. So this amendment number 6 is amendments to the definition of care arrangement to include records of relative foster care. And again, this was just an issue that arose at committee stage, and that I committed to going back and working with my officials to see if we had the definition right. So I'm pleased to be able to bring forward an amendment which further expands the definition of care arrangement to include formal foster care by a relative. So records related to a relevant person's foster care placement have always been included in the definition, and this amendment will ensure that where a relevant person was fostered by a relative, the records related to that placement will also fall to be released. So again, just a slightly broadening of the definition, recognising that foster care arrangements, while predominantly with non-relatives, on occasion did happen with relatives, and it is right that those relationships should be encompassed within the definitions. So again, pleased to be able to respond to the points that Deputy raised in committee.
Yeah, just really briefly, I don't want to end up saying the same thing, although I'm sure there'll be probably some more contentious issues later, but it is welcome to see some of the stuff that has been discussed at committee stage, and I suppose sometimes, you know, when you're going through pre-leg and committee and all the various stages, it is good to see the discussions that are had, that there is points taken on board, and, you know, as I've already said, like, just there's been so many different situations and examples and different stories from the time in our history of the Mother and Baby Institution. So I think it's really important that, you know, we have as wide a reach as possible for people to be able to access this legislation. So I would just welcome that. Thanks, Concordia.
Thanks very much. So again, this is another amendment springing from the discussions we had at committee stage. And they collectively remove the time limitation placed on early life information and care information. So when the bill was first published, the bill provided that the definition of early life information and care information were subject to a limited time period, which was deemed to end in the case of an adopted person at the date of their adoption, or in the case of a person subject to an illegal birth registration, the date on which their social parents assumed their role as parents. And Amendments 7 and 8 remove the reference to early life and care definitions being subject to subsection 2.2, while Amendment 17 deletes subsection 2.2 completely, thus removing that limitation. And I know that deputies did bring similar amendments at committee stage, and in response I stated that I would seek to have this timeline removed, subject to consultation with the Office of the Attorney General. So following that consultation, I'm happy to be in the position to remove subsection 2.2, and that means that the definition of early life and care information for all relevant persons will now extend all the way up to the age of 18. So I think both Deputy Batchik and Deputy Funchion raised this in the context of committee stage. We did say we'd go back and look at it. I listened to the arguments made, and we're making this change on foot of that.
Thanks, Concordia. I'm actually really delighted to see this in, because I think we actually had a number of amendments that were sort of similar and all kind of saying probably the same thing around the time frames and being restrictive. So it's good to see that, and I actually think I have a later amendment that can be withdrawn now on the basis of this. We'll see when we get there, but no, it is good. I'm glad, because that was one of the things that we were really anxious about, that there wouldn't be any limitations. So it's welcome. So this is in relation to the whole illegal versus incorrect, I suppose, and the terminology. And oh, sorry.
You're okay. But just to point out, just in case of any misunderstanding, 10 up to 13 are being discussed now together.
That's fine. I think that they're all they're all related anyway. So the same argument applies. And I do take the point on board that I think the argument for not using the word illegal is that the person has to prove that it was illegal, and that there might be difficulties around that. So I am a bit conflicted on it. But I'm wondering if the Minister's amendment number 2, does that make any changes? I know that's already been discussed, but does that make any changes to the whole incorrect illegal? Because I just think people feel so strongly about it, and rightly so, and we all, when we're discussing it and talking about it, we all reference it as illegal. Nobody really goes around saying incorrect. And it is an important point, I suppose, for people that are affected by it, that it's called out for exactly what it is. But I do understand it might pose difficulties too. But I'm not sure if 2 has any reference to this at all, but it would just be interesting to hear back from the Minister on that. Thanks.
Thank you very much, Deputies. And look, we had very significant discussions about the definitions, the definitions used in terms of what we all know, what we all recognise and what we all speak of as illegal birth registrations, and they were illegal. There was illegality involved in many of them, and the use of the term incorrect in the legislation. And I made the point that, you know, in mine and in the government's communications, and we've engaged very extensively with groups of people who have been subject to illegal birth registrations, we have always used that language, the language of illegal birth registrations. I also made the point that we want to ensure that people who were subject to illegal birth registrations can use this legislation, and they are defined in the category. But we also want to make sure that people who believe that they were subject to illegal birth registration, and that's an incredibly, there are, you know, 141 people who TUSLA identified from St Patrick's Guild, but there are others we know who have very good reasons to believe that they were always also subject to an illegal birth registration. And we want to ensure that as many people as possible can fit within the criteria, within the definitions of people who can use this bill, so they can use the provisions of this bill, both the existing provisions and some new ones that I'm introducing via committee stage amendment today, and particularly that tracing amendment that Deputy Bashik referred to a moment ago. And the concern that we have said throughout is that by using this phrase of illegal birth registration, by putting this in the legislation, it creates a very high bar to reach. That someone would have to demonstrate that they were the subject of an illegal birth registration. And that's why we use this term incorrect, which is a broader term. And I know that has caused concern, and in my communications on this, I've always tried to show that the sole reason for this is to have the definition wide, so as many people as possible can fall within the provision, and therefore use the provisions of this bill to possibly finally conclusively identify whether they were the subject of an illegal birth registration or not. And one of the provisions, again the one you referenced, Deputy Bashik, that we're bringing in today, will strengthen the ability of an individual to look back and see if they were subject to an illegal birth registration, but also for me as for the Minister, whoever the Minister is, to direct TUSLA or the AAI to undertake such a trace back. And that's really important, and that's a significant change for both individuals and for the Minister. In terms, Deputy Funchion, of Amendment 2, Amendment 2 doesn't change a specific definition here, and just be upfront on that. But I think Amendment 2, by bringing in this very substantial change to the Succession Acts, I hope is a further, demonstration by the government of our recognition of what was done to people who were subject to illegal birth registration, and our need to make very extensive and very novel legal changes to address their needs, to address this very difficult situation, beyond the absolutely traumatic emotional impact of this revelation, the very difficult legal situation that people subject to illegal birth registration have been made. And just to come back finally to Deputy Bashik's point, at committee stage, recognising that there was concern about the use of the term solely incorrect, that might be seen somehow as a diminution or a glossing over of what happened in terms of illegal birth registration, we brought forward an amendment. It was similar enough to amendment I know Deputy Bashik and maybe others brought forward. So now under the definitions section of the bill, so I'm looking at section section 54, and it says, for the purposes of this Act, a person is an affected person where, as a result of the giving of information that was false or misleading. So we added those terms, false or misleading, in terms of that definition of people who are affected, and thus recognising that there was falsity, there was in many cases a deliberate effort to misrepresent the existence of and the relationships there. We looked at this again since committee stage. I asked officials to examine and see could any of the changes that deputies are bring forth here today, could they be made, and the responses from the Office of the Attorney General, from Parliamentary Council, that the proposals that are being brought here, they would act to undermine the clarity and the inclusivity of the bill. So that's why, unfortunately, and much as all as I would like to take these amendments, we believe that they will undermine the clarity and the inclusivity of this bill. And I want this bill to be able to be accessible to as many people as possible who have questions on their identity. We want the wrongness of what happened to people recognised. I believe we've gone a significant way in terms of the amendments I brought forward at committee stage to do that. I accept maybe deputies, most importantly, I accept maybe some people who've been subject to this don't, but, you know, I have looked at this, I've done as far as I believe I can go to address the language used, while at the same time, in everything I've said and everything the government has done, we have recognised the illegality of what happened here. Thank you, Les Cam Corlett.